BBMRI ERIC webinar series. This is the first webinar we are holding, and it is my pleasure to introduce to everybody who is in listen-only mode, Victoria Chico, who is a lecturer in law at the University of Sheffield, has published a plethora of articles in leading academic journals, got her PhD published as a book, focuses her research in examining the legal role of information in consent to the use of health data and thinking creatively about disclosing health information to patients, research participants and their families, has a vast experience in the GDPR, which I think was over the couple of months one of the main topics, not for you, but for a lot of people. Victoria is also founding member of the Law and Governance Genomics England Clinical Interpretation Partnership, where she was involved, is involved in determining research priorities, which will drive up the value of clinical practice in the 100,000 Genomes Project. Victoria also holds an invited position on Sheffield Teaching Hospital Assisted Competition Unit Ethics Committee and is a member of the UK Pharmacogenetics and Stratified Medicine Network. And last but not least, is a member of the BBMRI Common Service ELSI. So thank you, Victoria, for agreeing to holding this webinar. Before I hand over to you, I want to repeat the typical housekeeping rules for such webinars. All attendees are muted. If any one of the attendees has questions, please post them as the presentation goes along in the chat. And we we attend to those questions in the last minutes of this hour. If any questions have not been answered, we will be able to do a follow-up after. So again, thank you, Victoria. Thank you for the team in making this happening, especially Viridiana sitting next to me and Johanna being on the line in the other room. And welcome everybody. Victoria, the floor is yours.
Thank you, Michaela. So I'll just put my slides up. Okay, thank you very much. What I want to do today is give a presentation that focuses on the impact of the GDPR in using personal data in the context of scientific research. I hope this is not too much of an Anglo-centric presentation because I'm based in the UK. Most of my knowledge is about how this applies in the context of UK law, but hopefully this will be a platform for us to start thinking about some of the differences that might apply across the member states. Okay, so the focus for, I can just go to my first slide. So I've decided to focus on these aspects of the General Data Protection Regulation. I've color-coded this presentation and the slides will be available afterwards. So as you go through, the colors should relate to one of these four colors. The colors of each slide should relate to one of these four colors on this slide, so you can see which part. These all relate to titles within the GDPR, so it should be obvious which part of the GDPR I'm talking about. So the aim of the GDPR is to harmonise the rules for all member states and to reduce legal fragmentation in the control of personal data. The GDPR does introduce, it provides greater protection for individual rights and introduces some new individual rights, which will be one of the key issues for processing data for research purposes and how much emphasis you need to put on respecting those individual rights depends on the lawful basis that you rely on for processing data. As I said, my focus here, because this is not a sector-specific regulation, my focus here is particularly on the implications of data processing in the research context. And some of what I say will relate particularly to the biobanking context, given my focus as the UK representation for the BBMRI ERIC ELSI group. Okay, so as I said, the GDPR covers all processing of personal data, and it seeks to be protective and is an inhibitor in lots of sectors. It actually gives people much greater control over the uses of their data. It's not necessarily seen as being such an inhibiting force in the context of the use of data for scientific research. Therefore, in that context, I think it can be seen as much more of an enabler. So throughout the regulation, we see that there are exemptions from the provisions when data is being processed for scientific research purposes. The data doesn't, the regulation doesn't apply to anonymous information. Now, that in and of itself is a very complex phenomenon, and in the UK, the Information Commissioner's Office provides a code of practice on anonymisation, and it's quite a lengthy document. They're currently rewriting that to reflect the principles in the General Data Protection Regulation. So, but if you can fully anonymise information, then it falls outside of the General Data Protection Regulation. So this usually means where data is properly aggregated and published in an aggregated form. It does apply to pseudonymised data, which would be seen as being identifiable under the General Data Protection Regulation. This is quite an Anglo-centric slide, but our supervisory authority is the Information Commissioner's Office, and this slide is drawn directly from their website. This is really an issue of legal compliance, and I don't really want this talk to be too much about legal compliance. But nevertheless, this is the 12 steps that our supervisory authority is recommending that institutions take now to make sure that the organisation is ready for the implementation of the GDPR on the 25th of May. And then other supervisory authorities in other member states will probably have something similar, but this can be accessed directly on the Information Commissioner's Office website. So, the General Data Protection Regulation is centred around a number of principles, and these can be found in Article 5 of the regulation. And these principles apply across the board to the processing of personal data. However, we see that even at the level of the principles, there are significant exemptions where you are processing data for the purposes of scientific research. So one of the key principles is that the purposes for which data is processed should be limited to those purposes for which the data was collected. So data normally has to be collected for specific purposes, and then it can't be further processed in a way which is incompatible. However, what we see is that where the data is being processed for scientific research purposes, then there's a presumption that that won't be incompatible with the initial purpose. So we already see an exemption from one of the key principles of the Act. And this is obviously about, Article 5b is obviously about reuse of personal data, but there's this presumption that reuse for scientific research purposes will not be incompatible. One of the other important principles in Article 5 is that is the idea of storage limitation. So we don't store data for longer than we need to, and it is only stored where it's necessary for the purposes of processing. Again, in the research context, we find that data may be stored for longer periods. It may be kept for periods prolonging or longer than the initial purpose if it is going to be further used for scientific or historical research purposes. So these kind of research exemptions are being drawn through the Act right from the beginning of the kind of principles of the GDPR.
I'm really sorry to interrupt. Could you please switch to full screen mode?
Let me have a look. Sorry.
Yeah. There you go. Perfect.
Is that better?
Thanks.
Okay, so moving on We've changed colour, so moving on here to the legal bases for processing. And this is one of the questions that I get asked about most when I'm talking about the General Data Protection Regulation to people, to organisations and researchers in the UK. They want to know about the lawful basis for processing. So you have to have a lawful basis for processing, and you have to be under the transparency and accountability requirements of the GDPR. You have to be very clear about what that lawful basis is. The general lawful bases are found in Article 6 of the Act, and there are 6 of these. They're not particularly specific. They're quite general, really, and they can apply to lots of different contexts and lots of different situations. One of the things that's quite interesting from the research perspective is that consent is often put on a pedestal, and I think particularly in the context of biobanking research, it historically has been the basis for a lot of processing of personal data. Even though you don't currently need to publish the legal basis, clearly most legitimate research outfits do have a legal basis in mind where they are processing personal data. But the policy position in the UK is currently that where an organisation has, as part of its requirement, or is allowed to perform research, that research could be done in the public interest or in the exercise of its official authority. And in the UK, hospitals and NHS organisations and universities are seeing as doing research as part of their official authority. So where they're processing data for research, they don't need to necessarily rely on consent as the lawful basis for that, because they can do this, they can process that data, that personal data anyway, on the basis of public interest or on the basis of the fact that it's in their official authority to do so. This only applies to 2 public authorities. It doesn't apply to charitable institutions or pharmaceutical companies. Now, they would have to rely on a different lawful basis to process personal data for research purposes. And again, the policy position seems to be that they're guided to use legitimate interests as their basis for lawful processing. This does require them to do a little bit more than public authorities are required to do under their official authority, because the legitimate interest grounds does require you to demonstrate why you need to process that data for those interests, and to show that it doesn't actually interfere with the data subject's fundamental rights and freedoms. That's not the end of lawful basis, because if you're processing a special category of personal data, then you also need to fulfill one of the conditions in Article 9. And because health research is often processing data about health, the organisations and researchers who are processing that data will also need to ensure that they have a condition for processing special category of personal data under Article 9. And what Article 9 does, it generally is prohibits the processing of this type of data, the special categories of personal data, unless one of 10 conditions applies. So we can see here that genetic and biometric data and health data both fall within special categories of personal data. Now, I haven't listed all of the 10 conditions here. I've particularly focused on 2 conditions that I think are important in the context of processing data for the purposes of scientific research. And historically, like I said, I think that what's been particularly important in processing special categories of health data has been the explicit consent of the data subject. However, we know that the GDPR provides a new ground for processing special categories of personal data, and this is under Article 9.2j, and this is where the processing is necessary for archiving purposes or scientific or historical purposes. Okay, now we often refer to this Article 9.2j as the research exemption. But what you need to do if you want to rely on this exemption, what becomes very important is Article 89.1, because if you want to rely on the research exemption under Article 89, then you can only do that if you can show that your processing is in accordance with Article 89.1 and the safeguards in Article 89.1. What I've written here is an exact reproduction of Article 89.1, so sorry it's such a wordy slide. But what's particularly important here is that the organisation and the researchers have in place the technical and organisational measures to ensure the respect for the principle of data minimisation. So this is generally about how systems are set up to manage the use of personal data in research. So this is quite important, and I think this is one of the areas where we get a significant, under Article 89 and the research exemption, we run the risk of having significant disharmonisation across member states, if you like, because this is one of the areas where the GDPR provides for member states to enact their own provisions, providing derogations from the rights that are contained in the General Data Protection Regulation. And we know that in the UK we currently have a data protection bill which is in the final stages of going through Parliament, and it does provide for derogations from all of the rights which it's permitted to under Article 89.2. So yeah, this is where there's significant scope for different regimes within member states. Okay, sorry, that's probably what I've just said. So yeah, the Data Protection Bill in the UK does provide for that rather significant derogation. So what do data controllers need to do in order to show that they are demonstrate their legal basis, their lawful basis for processing? Well, they need to publish this, and this should be clear in the privacy notice exactly what the lawful basis for processing is. And this is a new requirement. So many people are currently making amendments to their privacy notices in order to reflect to data subjects what their lawful basis for processing is. Changing colour again here, I want to talk particularly about consent just for a few moments, particularly because I think that consent has been the historical gold standard for processing of personal data in the context of research. And in the UK, there is a massive shift away from relying on consent, and the way that the GDPR seems to provide for that move away from consent is really being harnessed in the advice that is being given to research organisations. So under the General Data Protection Regulation, there is a definition of consent under Article 4, and it says the kind of things that we always expect to hear about consent, that it must be informed, it must be freely given, it must be unambiguous, it must be specific. It's clear that consent needs to be an affirmative action, so there's no such thing as opt-out consent. You can't have a pre-ticked box. Somebody has to actually do something active in order to demonstrate that they do consent to that processing of their personal data. It doesn't need to be a signature. It could be ticking a box, but it can't be unchecking a ticked box. The General Data Protection Regulation doesn't give a definition of explicit consent. And if I just go up slightly, you might remember that the lawful basis for processing special categories of personal data in Article 9(2)(a) requires that the subject gives explicit consent. In the UK, the way that that's been interpreted is that there needs to be a specific statement saying that the person gives consent. So the Information Commissioner's Office has said where explicit consent is required, it needs to be more than an affirmative action. So there needs to be something specifically saying, I consent to the use of my data or the processing of my personal data for this reason. And this has been important in things like where we may have presumed consent, where somebody fills in a health questionnaire for the purposes of research. We may have presumed consent as an act of actually filling in the questionnaire. And it seems that if we're relying on explicit consent, that won't be sufficient, and that actually there will need to be a specific statement. Obviously, if you're not processing a special category of personal data, then it may be that consent can just be signified by this affirmative act and you wouldn't require that explicit statement. But it may be that other member states have interpreted that slightly differently. So where processing is based on consent, the onus is on the data subject to demonstrate this. And this can be quite problematic in certain circumstances. Consent can't be bundled up with other consent to other processing which is not required for the particular purpose. So it needs to be disaggregated from things that it's not related to. Maybe if you do have to consent to both of the two things in order for that processing to happen, that's okay. But if you're being asked to consent to it as part of something else, and you don't need to consent to both of those things, then it would not be seen as freely given. And where processing is based on consent, there has to be the right to withdraw consent at any time, and this needs to be just as easy as it was to give consent. So if you can give consent by text, you need to be able to withdraw consent by text, and you wouldn't. It wouldn't be just as easy if you had to go through a lengthy telephone process to withdraw your consent. So consent is one way to comply with the GDPR, and as I said, the policy position in the UK is that it is in no way elevated over the other lawful basis in the GDPR. Particularly, some institutions may be being advised to move away from using consent as the lawful basis because of difficulties in the GDPR of demonstrating that consent is freely given. So we have quite a all-encompassing definition of what a public authority is in the UK. And the GDPR says that there is a presumption that where there's an imbalance of power, and it gives the relationship between an individual and a public authority as being a paradigm of that imbalance of power. And it says that consent cannot be considered to be freely given in those circumstances. So public authorities are well advised to rely on an alternative basis to consent, on the basis that it's going to be difficult for them to demonstrate that the consent was freely given. So because consent is not preferred over other legal basis, there's been this big shift away from consent as the lawful basis for processing in the context of processing data for scientific research purposes. Nevertheless, the problem that we're having in the UK, and hopefully this does chime with the problem that people are encountering in other member states, is disaggregating what's required under the common law duty of confidentiality by way of consent and what's required under the General Data Protection Regulation. So the General Data Protection Regulation doesn't affect the common law duty of confidence. So in the UK, that comes from our case-made law. And where you collect health data about people, then you almost always will be doing that in the context of a confidential relationship. And that's particularly an issue where you're collecting it as part of their healthcare. The organisations would not need to change their consent practices to comply with the GDPR in order to maintain confidence. They're two very separate regimes. And in England, the consent requirements in order to negate an action for breach of confidence are not the same as the consent requirements to provide a valid consent under the GDPR. So in many circumstances in England, we actually rely on implied consent for processing personal data in a way that doesn't breach confidence. So when a patient gives information to a health professional, that information will be used in many ways which are for the care of that person. So they'll be passed to other people involved in the care, they'll be used for auditing purposes, and it will be taken that the person impliedly consents to that. In England, data may also flow for research purposes without patient consent under other statutory bases. So you don't need to give an explicit consent to many flows of patient data. However, this will not suffice for the GDPR. There's no such thing, I don't think, as implied consent under the GDPR. But you do need to still ensure that you meet the common law duty of confidence. So one of the problems that people are having getting their head around is that they may need to get a consent in order to ensure that they are meeting their common law duty of confidence, but they may rely on a different basis under the GDPR. So consent for confidence, and then rely perhaps on the fact that they're a public authority and the research exemption in order to meet their data protection regulation responsibilities. So it's only if you're relying on consent as the basis for your lawful processing under the GDPR that your consent needs to be GDPR compliant. So what does this mean for the concept of broad consent under the GDPR? It does seem that the concept of broad consent is to a certain extent preserved, but this is really only clear from the recitals rather than from the articles. But the recitals do allow for people to consent to certain areas of scientific research rather than consenting to specific research projects. So that it does still preserve this idea that consent doesn't have to be something that only relates to one specific project and then you need to get a new consent every time you ask somebody to be part of a different research project. This hasn't been particularly fleshed out in the UK because, as I said, the policy advice from most of the government organisations is that researchers and data controllers and data processors shouldn't be relying on consent for the processing of data for scientific research purposes. And one of the things I'm quite interested in is whether this actually sets us apart from other member states where it may be that consent is still seen as being much more important lawful basis. So changed colour again here to move on to a different chapter of the GDPR, and that's the chapter that we find in Articles 15 to 22, which details the rights of the data subject. So this is one of the new developments, I think, in the GDPR, this focus on the fact that people should have greater control over their personal data. And where data is processed on the basis of consent, people do have a very high degree of control over what happens with that personal data. Like I said before, they retain the right to withdraw. The right to withdraw is quite stringent in that it needs to be just as easy to withdraw. There's also a new right under the Act of which is the right to data portability, which means that the person has to be provided with data regarding him or her in a structured, commonly used and machine-readable format, and they need to be able to transfer it to other data controllers without hindrance. If we go back to Article 89.2, this was the article that bites when you rely on the research exemption under Article 9 of the GDPR. And this is the place where the GDPR provides for derogations from the rights in the regulation if those rights those derogations are provided for by way of a national legislative act. Now in the UK, we have provided in the Data Protection Bill for derogation from all of the rights that we are able to under Article 89.2. So where data is processed on the basis of the research exemption in UK law, all of the rights, the right to access, all of the rights which we're allowed to, the right of access, the right to rectification, the right to restriction, the right to object will all be restricted under those derogations. There are further specific provisions relating to the rights, and the right to erasure can be derogated from under the article itself, under Article 17, where that processing could hinder the purposes of scientific research. So national regulation is not needed in order to derogate from the right to erasure. That that ability to derogate in the context of scientific research is actually provided for in the article itself. So again, we see that where we rely on the research exemption, the Act is an enabler again rather than an inhibitor. So it's trying to marry up or it's trying to balance the data subject's rights, but also the ability for scientific research, which is in the public interest, to go ahead in a way that maximizes the potential of that research. Okay, so hopefully that was a little bit of a whistle-stop tour, but I think hopefully I've given you some idea of how the concept of lawful basis might be interpreted in the context of scientific research, and talked about the fact that consent is perhaps difficult to achieve in many circumstances where data is processed for the purposes of scientific research, and actually it might be easier for research organisations to rely on alternative legal basis, and if they do that, it might provide much greater freedom for them to be able to do that research without having the hindrance of some of the data subject's rights that they'd have to fulfil if the basis for the processing was consent. Thank you for listening.
Thank you so much, Vicky, for this presentation. And as you can imagine, we have a couple of questions. I will read them out, then tackle them one by one. The first question is by Brian Clark regarding lawful basis. If you have consent, isn't this used as the lawful basis rather than the recommended options of public interest, public authority, or legitimate interest?
If you have consent. Sorry, I missed a little bit of the question, Michaela.
Yes,
if you have consent. So if you currently have consent and your consent is already GDPR compliant, then you don't need to do anything. If you still want to rely on consent, so you do need to be aware that that means that people need to have the right to withdraw that consent at any point. But if you have a consent which is GDPR compliant, then you just need to publish that as your legal basis. You don't need to change your legal basis at that point. You just need to publish that. Some people whose consent, where organisations are relying on a consent which is not GDPR compliant, they do have the ability to change that lawful basis and publish a different lawful basis if they find that the consent is not GDPR compliant. If they can't find an alternative lawful basis, then they would have to refresh that consent to make it GDPR compliant or stop the processing.
I will switch to a related question from Kathy Turner. Do the new regulations apply to data collected before they came into force?
Yes, if you're still processing data, then you need to make sure that you are doing that in a way which is GDPR compliant. So it's often said that the GDPR is retrospective, and it's not. So one of the requirements of the GDPR, which I didn't actually talk about in this presentation, is the requirements in Article 13 and 14, whereby you need to provide information to the data subject about information to be provided where you have collected data from the data subject, or where the data has been collected from a different, have not been obtained from the data subject. When you're thinking about giving information, so this is whether you're relying on consent or a different legal basis. This isn't giving information to underpin a consent. You have to give information anyway as part of your privacy notice, whether you're relying on consent or not. The point at which the information needs to be given is when the data are collected from the data subject, or if you're repurposing data at a point before you embark on that further purpose. If you're just still in the process of processing data, You don't necessarily need to go back to all the participants and give them, all the data subjects, sorry, and give them information, but you do need to make sure that your processing is lawful under the General Data Protection Regulation. So you would need to identify what your lawful basis is and make sure that your processing was in line with the General Data Protection Regulation.
In that regard, if you permit me a comment, the general guiding principle of the GDPR is, of course, accountability. And in that sense, also the decision which legal basis to base your processing on has to be made and accounted for.
Yes. Yeah. So you would need to publish that as part of your privacy notice.
A related question comes here again from Brian Clark, that is on regarding lawful basis. Give me a second. Yes, can you have and use more than one single legal basis for processing the same personal data?
As far as I'm aware, you have to, I mean, just because you rely on a legal basis doesn't mean that you couldn't demonstrate that the processing is also lawful under an alternative lawful basis. But as far as I'm aware, you have to have one lawful basis, and you can't say, well, if it's not that, it's that. That can be particularly problematic, and I think the Article 29 Working Party guidance touched on this. That kind of approach where you could say, well, maybe it's this or maybe it's that, can be particularly problematic if you are relying on consent, because consent needs to be real and it needs to give people a genuine choice. And if you say, okay, we'll rely on consent, hang on a minute, if you don't consent, then we'll rely on legitimate interest, then you're not really giving them consent, because if they don't consent, it looks like you're just going to rely on another legal basis. So that is not allowed. And if it's two other legal bases, if it's, for example, legitimate interests or a task in the public interest, that's less problematic. But I think for clarity and transparency, which again these are overarching principles upon which the GDPR is positioned, there should be a single legal basis.
Mm. I recently had the chance in discussing this with DG Justice, and they also referenced the guidelines as you did on the Working Party 29, and it seems that the interpretation is indeed you can have more than one legal basis, but you cannot switch the legal basis as you go along because you did not like the other one, so you have to be consistent.
Yeah, so there seems to be a one-time ability to effectively change your legal basis before the GDPR comes into force, because before the GDPR there was no requirement to publish what your legal basis was. So organisations might not have thought so clearly and in a defined way about what their legal basis is. So it may be that you thought you were processing upon one legal basis, perhaps upon consent, but it's clear that that consent is not GDPR compliant. So it may be that you want to change to legitimate interests or to task in the public interest, but that won't be something, like you say, that you can do as once you've published that legal basis in line with the GDPR. You can't keep changing that legal basis to reflect different kind of other legal basis.
The next question is from Oscar Brito Fernandez. Does the consent of the data subjects always have to be in a written form?
No. So it needs to be signified by an affirmative act. So it doesn't need to be written. It doesn't need to be a signature. It can be a tick box. The distinction that we've made in the UK, and like I said, I think this is quite Anglo-centric again, it may be that other supervisory authorities have not said quite the same thing. But the Information Commissioner's Office has said where you're relying on explicit consent under Article 9, there must be a way of reacting to a specific statement about consent. So the tick box must say something along the lines of, I understand and consent to my data being used for this purpose. It's not enough just to fill in a questionnaire and send it off, but that might be enough in relying on consent under Article 6, where you're not processing a special category of personal data, because that affirmative act would be sufficient to show that a person consents to the data being used for that purpose. So it doesn't have to be written, but it needs to be an affirmative act.
The next question is, within a healthcare organization, a professional that gathers personal data from the workforce elements for mandatory reports can be responsible for any GDPR violation, or is it the organization's responsibility at all times?
Workforce data. Now this is quite complicated because this is really an issue of employment law, and there are some particular concerns around workforce data. I'm not an expert on that. It probably would be best to ask an employment lawyer if you're dealing with human resources issues. If you are keeping data about your workforce, normally there will be a legal a mechanism in national law for doing that, and it may be that you can rely on lawful basis other than consent. So what you would be expecting here is that perhaps you're relying on the fact, the legal basis is the fact that you the processing is necessary for the performance of a contract, because obviously a contract of employment will exist, and that will be significant, I think, in the context of employment law. If you're keeping data about employees and the reason for doing that is pursuant to a contract, you may again also be able to rely on the public interest if you are required to keep information about your employees, perhaps for their safety or for other reasons of kind of national safety. But you would need to show that it was more than your own economic interests. But workforce data, definitely you can process that under a number of the lawful basis under the GDPR. If there was some unauthorized further disclosure of that that workforce data, then I think the organization would be liable for that if it had not made sure that the safeguards were in place to protect that data from unauthorized disclosures.
We have about 10 more questions, and one of them would be, could you please specify whether or not we need to anonymize archive data? We have conflicting information. This is by Julie Toms.
It depends on what you are using it for. If you anonymize data, then that, I'm not sure what, so archived generally, I guess that could apply across lots of different sectors. If you anonymize data, and it's anonymized in line with, in the UK, we have the Information Commissioner's Office Code of Practice on anonymisation, and that's the gold standard for making sure it's properly anonymised, then it falls outside, it's no longer personal data. And that means that data protection regulation doesn't apply, so none of the data protection law applies, neither does the common law duty of confidentiality. So there you can use that data outside of the context of legal regulation. I mean, you may want to consider for the purposes of public trust, for example, if how the public would feel if they found out that anonymized data was being used, but it doesn't fall within the context of the general data protection regulation. Determining whether you need to do that or not is a different question. I don't think I have enough information to tell you whether or not you would need to anonymize the data, archive data or not. I mean, if you're holding it and you think there's a lot and it's identifiable and it you want to use it in identifiable form, then you need to make sure that you have a lawful basis under the GDPR. But I think I'd need a little bit more information to know whether you absolutely need to anonymise it. I haven't seen any situation where anonymisation is absolutely required.
I think this also plays into the discussion across Europe of anonymization, pseudonymization, and different understandings in different legal realms. I think this is worth to revisit in a even specific webinar on it.
Yeah, absolutely. I mean, anonymization is a huge issue, and you know, one of the things we grapple with regularly is anonymous to who. So when you're talking about pseudonymized information and somebody has the key to the identifying that individual, if the particular organization doesn't have the key, they just have the anonymized information. Currently, the policy position in the UK is that's anonymized data because they cannot access it because a different organization holds the key. Now, our anonymisation code of practice is being redrafted currently, and whether or not that will still be the position with the new code of practice, I don't know.
And within the Working Party 29 and also EDPS DG Justice, the understanding and interpretation for Europe is clearly, if there is a key somewhere lying around, it is always regarded as pseudonymized data, so never anonymized, and has to fall under the GDPR. I personally feel that this discussion is still somewhat ongoing.
Yeah, no, I do as well.
The next question is from Kathy Turner. Is the right or not to be recontacted covered? For example, if information with implications for the subject's own health is discovered as part of the research.
Okay, this is really complicated. If you have collected data for the purposes of somebody's direct care, and you discover something about them, and you are part of the clinical care team, then you would be able to recontact that person on the basis of that relationship with them, and that would fall under a different lawful basis. If you are processing somebody's data for a research purpose and you want to recontact them for some reason, then that should be covered. That processing of data should be covered, particularly if it's for their interest, should be covered by the lawful basis that you are relying on. And some of the issues that we're having at the moment is with regard to consent for consent. So where you're asking somebody, asking for somebody's details so you can contact them to get their consent to be contacted for consent to future research studies, and how to determine the lawful basis for that under the GDPR. But it does seem in the same way that the lawful basis of tasking the public interest and scientific research would apply in the same way. So you're processing that data for scientific research, and this would seem to, for the purpose of scientific research, and I think those kind of things would fall within that. You wouldn't need to get a separate consent for recontact.
The next question is from Emily Binolo. Does GDPR compliant consent need to be more detailed with regard to the different scientific projects planned, which will necessitate processing?
Yes. So if you're gaining a consent to a scientific study, what you're normally doing there, if you're basing it if you're basing inclusion in the study on consent, is gaining a consent for the research, which will often, human research may include certain risks, and there will be side effects to the intervention that's provided to patients as part of the research. Now that's entirely different to gaining consent for processing of data. So legally you need to divest those two types of consent. So there are very, very few situations in which you can perform research on somebody without getting their consent, and that usually only relates to people who lack capacity. So let's just put that aside for the moment, because that's quite a complex area. If you're dealing with capacitated adults, then you need to get their consent for research interventions. The question of whether you need to get consent for the processing of data that you do within the context of that research is different. So you could get consent for the risks of the research, but then rely on legitimate interests or a task carried out as part of your official authority and the research exemption for the processing of the data that occurs as part of that scientific research. But that doesn't mean that you don't need to get the consent to the running of the risks that might be involved in the research. And it's the same to medical treatment. If you consent to a medical treatment, there's absolutely no alternative to performing medical treatment on a capacitated adult than having their consent. Okay, there's no such thing as it's in the public interest, or it's it's for your vital interests. You can refuse to have a medical treatment if you so choose, even if you will die. That doesn't change, but the processing of any data that's generated as part of you having that treatment doesn't need to be upon consent in the same way. So again, you can consent to the medical treatment, but the GDPR would allow data that arises from that to be processed on the basis that it's carried out as a task in the public interest or official authority, and then, for example, the research exemption, or there are exemptions relating to medical treatment and public health. Sorry, that was quite a long-winded answer.
The next question would be, BBMRI has always promoted broad consent. This will be changed. Will this be changed, and the focus put on research exemptions?
That's a really difficult one. I think the biobanking community particularly is very much wedded to the concept of consent. And I think that's very important for public trust in the concept of biobanking. And we are having that discussion quite a lot in the UK. Consent outside of that, data processing outside of that context is very much moving away from consent, but it does seem that the biobanking community is still one kind of niche area of research that is still focusing on consent. And it may be that that's going to take a little bit longer for that community to feel that it can move away from consent. And I think that's why it's important to say that recital 33 of the GDPR does preserve that ability to be able to ask people to consent to broad areas of research. But you do need to remember, if you're relying on consent, that it's much easier for people to withdraw, and you do need to make sure that the other kind of rights are provided for. Whereas if you rely on the research exemption, it's a bit easier to use that data, and you're not so worried that people will be withdrawing their data and affecting the data sets. So I mean, it's not they must move away from consent, and I think there may be some projects where consent is actually preferable for the purposes of maintaining public trust, because if you don't get public buy-in, then the whole kind of project itself could become less valuable. So I think it's a kind of judgment issue as to if moving away from consent is actually going to affect public trust, then that needs to be carefully thought about.
We have another 6 minutes left until we have to end today's webinar, and we have more questions than we can answer. But I want to reassure everyone that those answers that have not been yet addressed will be answered as a follow-up. We will make it available in one form or the other, and keep you posted over the next days. Another question that is seen critical is, are there guidelines on how research organizations should publish their lawful basis for processing data?
Yes, I can only speak for the UK again. So one of my other roles is as a data policy advisor to the Health Research Authority. And the Health Research Authority is the body which protects the interests of the public in health research. We've published a number of high-level technical briefing documents on the Health Research Authority website. We've also published operational guidance, which should be really helpful. So that's on the Health Research Authority website as well, which should be really helpful to people in determining exactly what they need to put in a privacy notice, how they need to specify what their legal basis is, what information they need to give to individuals, at when they need to give that information. Now that's specific to the health research sector. NHS Digital, which is again another UK institution, which is the technology spine of the NHS, as their information governance authority has published again a suite of guidance on how the policy position of conforming to the General Data Protection Regulation in the processing of health data for healthcare purposes. So both of those are really good resources to access, and I suspect that again similar organisations in other member states will have provided the same sort of policy guidance.
I can answer here for our BVMRI Common Service ELSI. Within the team, several of our experts are involved either in even the drafting of the guidelines or know where they are. We are aiming in collecting them and making them available on the website. As a lot of them are in the making, I think that we can expect some guidelines to be ready and accessible for you before the GDPR enters into force, and some only a couple of months afterwards. So it will be an ongoing thing. The next question, and the second to last, would be, could you please comment on the success of UK moving from consent as a legal basis? Are there any of the other legal bases preferred for health research purposes?
Yes, there are. So moving away from consent under Article 6, we would be expecting for any NHS organisation that has research as part of its task, or any university, and almost every university has research as part of its charter, to rely on a task carried out in the public interest or in the exercise of official authority. So that's Article 6(1)(e). Charitable organisations and pharmaceutical companies can't rely on that because they're not public authority, but they would be expected to rely on Article 6(1)(f), which is processing is necessary for the purposes of legitimate interest pursued by the controller. That does require them to do a little bit more in their privacy notice to justify their lawful basis, because they need to be able to say it's for more than their own economic gain, but that shouldn't be a problem for most charitable and pharmaceutical research. If they are processing a special category of personal data, which obviously if they're doing scientific health research, they almost always will be, then it seems that they would almost always be relying on the condition of Article 9(2)(j), which is the research exemption. Like I said, there are other exemptions under Article 9 if you're processing data for the purposes of healthcare, providing healthcare, or in areas of public health. So there are a number of conditions that you can rely on, but I think where you are processing data for research purposes, and that's health data, then you would be relying on the research exemption under Article 9 if you weren't relying on consent.
The last question that we can tackle today is, can the processing of genetic data be carried out under any of the legal bases, or do you need to have consent? By Abby Ryan.
You don't. Genetic data is a special category of personal data, and you can process that under any of the legal bases that I've talked about. It doesn't have to be consent. Obviously, there are special considerations with regard to genetic data, and a lot of those do relate to issues of identifiability, and if you wanted to anonymize it, how easy that would be. But it doesn't it's listed in Article 9 as a category of special data, but it doesn't get any special protection, if that makes sense. You could still rely, for example, on processing it for a task in the public interest and the research exemption. You don't necessarily need to get consent.
Thank you. It is 3 o'clock. We have to end the webinar. I want to thank you all for attending. We had, at the highest peak, 224 attendees. I think we managed all technical glitches. We could answer a lot of questions, and we will definitely have a follow-up webinar on the GDPR. A special thanks to you, Vicky, for being available and giving this excellent overview, and also for the staff here, that is Biri, who is sitting next to me, and Johanna, for making this all possible.
Thank you very much. Thanks for listening.